Trademark is any signifier. It can be a word or a design, a logo, a slogan, any signifier that you use to create an association between your company and the products the goods or services that it provides. So that would be Dunlap, Bennett, and Ludwig is the brand of our law firm. Coca-Cola is a famous brand. Anything that creates a connection between a product or service and your company in the eyes of the consumers.
To be clear, you cannot trademark your idea. You cannot copyright your brand. And we hear that sometimes, but quite simply, a trademark can also be a scent. It can be a sound, the NBC ding, 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 that can be trademarked. You can't trademark useful items. So if you think, oh, I could trademark a perfume scent, you couldn't. But for example, the smell of Play-Doh, for some reason, is trademarked because it doesn't apparently add any useful functional value to Play-Doh. You can still play with Play-Doh, but they've trademarked that smell, which again, I don't know that it's a good smell, but there it is. So trademark can really cover anything that creates an association in a consumer of whatever that service or goods are. It creates an association with that word, phrase, sound, or smell in the mind of the consumer. That's a trademark.
Or color.
Or color.
Trademark a color.
Trademark a color.
Yep. Now that we understand a little bit more about what we can and cannot trademark, can you tell us more about the protection that a trademark creates and why it's so valuable and necessary?
Okay, so I think the evens are mine. So the value of a trademark, and so what we're talking about, Tessa, is not the value of a trademark, because you get a trademark as soon as you start using your brand in commerce in association with your goods or services. Use in commerce is king. That said, registration gives you a whole bunch of things. So first, the process of registration, including the search that you do before registration. We'll talk about why search is important in a minute. But it lets you know if there are other users of your brand out there, and it puts the world on actual notice, or it gives some users who haven't checked the registry constructive notice, it gives them notice that you own this trademark within the boundaries of whatever country you filed a trademark in. And to put a little pin in that, or a note to that, is that your trademark is only valid inside the national borders of where you filed. So if you file a US trademark, you are not protected in Canada, the UK, or Europe. You can be, and we have signed something called the Madrid Protocol, Madrid Treaty, the US has, that allows us to file in all these other countries relying on our US trademark. But you're not protected there unless you take that step. And in the United States, to do that, it requires use. And I don't know if now's a good time to bring it up, but I always tell people, they're like, well, what if I just keep using my trademark? You said use in commerce is king, and I have a valuable trademark. Great. So if I'm in the DMV area, DC, Virginia, Maryland, this area where David and I are sitting right now in our office, and I open up a pizza shop and I start selling my pizza under the name, I don't know, Bobo John's. Probably have a problem with Papa John's, whatever. I sell it under that name, and another company opens up in California and they start selling in California, and then they go online like, you know what, we're going to sell these by mail order, and they start selling around the country and they file a trademark. Even though they did so a year after me, if I've only been using it in DC, Virginia, and Maryland, they filed their trademark. I've now lost the ability to go anywhere else in the country with my brand if they've registered their trademark. I will have concurrent use rights, and you can file something called a concurrent use petition. I won't go into that. So I will have rights to continue using my mark if I started using it first, but I've lost the ability to nationalize my brand because I didn't register the mark. So there are things about registration beyond the mere fact that it also can give you enhanced damages. And am I bleeding into another question? I don't know.
Okay, they all kind of relate.
They all kind of relate. But registering a trademark is different from having a trademark. And registering, putting it on the USPTO is very important. And part of that value, of course, is it damages, potentially punitive damages, which almost never get awarded, and attorney's fees, which almost never get awarded. But it does make them available to you. And without that registration, they really aren't.
Yeah. And it also just protects.
That, what are some issues a federal trademark registration would deter or perhaps help alleviate?
Right. So as Tom was saying, the federal registration gives you this nationwide protection, and it's not limited to a certain regional area. So it gives you broader protection nationwide to prevent other infringers. But it also has these enforcement provisions that'll help deter infringers because you have punitive damages and the ability to recover your attorney's fees. So if you have that registration, it's a lot easier to get a potential infringer to stop using the mark and to shut down their business. And when we talk about brands, of course, we're talking about marketing and ad and spend. So when you're spending money to build a website, to put up a billboard, to put a TV commercial, all of that money is investment in that brand. And if your brand is not protected, those dollars could be lost. If somebody then comes at you and says, we have prior rights to this trademark, and you just spent $1 million on a Super Bowl ad, those $1 million are gone. No consumer is going to associate your company with that ad because you now have to change your name.
I mean, if you spend $1 million on a Super Bowl ad without a trademark registration,
right.
you're kind of not running your business the right way. But that said, David's point's valid. You're not just losing the trademark filing fee, you're also losing time. If I register my trademark, if I don't register my trademark now and I go ahead and use it, or the registration itself gives you first, do we talk about time on the register? The first person to get to the USPTO's register is the owner of that mark as far as the register is concerned, even if there are other users around the country. You now own it nationally. Again, they may have what I described earlier as concurrent use rights in their geographic area, but you now are the national big daddy of that trademark. And so that's another very important reason to register the mark. And you want to be the person sending the cease and desist, not the person getting the cease and desist. And if you have that registration, you're going to have a lot more ability to do that.
So. Wonderful. And when we're thinking about time and cost, what advice would you give to anyone watching who's at the beginning of this process and they're worried about how much it's going to cost to file their trademark or how long it's going to take? What feedback would you give somebody who has those concerns?
So the first thing, I'm Evans, right?
Yeah.
So the first thing is a trademark search. A lot of people are like, well, I want to save money on my trademark. And I always tell people the intellectual property, if you have a website at all, no matter what you do, the most important thing about your company is the intellectual property, is the brand. I can open a flower shop. David can open a flower shop, and Tessa, you can open a flower shop. If my brand is 1-800-Flowers, I'm going to sell more flowers than you, not because my flowers are better, but because I have a brand that everybody knows. I can't do that because somebody owns that. But the point is, brand is so important. And sometimes people say, well, no, but actually selling the flowers is more important. Yes, that's important, but it's really not the most valuable thing your business has. So that's part one of the value and the cost. So cost. So there's a couple ways to look at cost. The first thing you should do, regardless, before spending any money on an actual application, is a trademark search. Pay for the trademark search, pay for an attorney to do the trademark search. I think that's a separate question, but that lets you figure out how many other competitors there are and whether or not your trademark is already owned by somebody else before you spend the money. Generally, it takes, right now, the USPTO says that it takes 8.2 months for them to respond to the first office action or first response from the USPTO. A first response from the USPTO could be, hey, your trademark's approved, we're going to publish it. Or the first response more typically is an office action of some kind. Why is that? Because USPTO examiners get bonused when they issue office actions, keeps the system honest. But you can expect that it will take an attorney 3 days to 8 days to get your application together and you to approve it and maybe go back and forth on goods and services. And you can expect that it will take the USPTO about 8.2 months as of July, and it was 8.1 in May. So it's not getting shorter, although their target is to get it shorter, but it's taking them that long to respond. And then final disposition of the average trademark, according to the USPTO statistics right now, is 13 to 14 months. So you can expect to actually have a registration at that time. Now, caveat to all of that, your trademark registration date isn't as important as your filing date. Because remember what I said, we're a first to file country. So the first person on the register has that registry right ahead of everybody else. So even if 5 other people file the same trademark after you, and if for some reason their applications get approved before yours, your rights precede theirs. That would be should be impossible, at least in the US. Might happen in other countries. But again, that filing date is of paramount importance. And yes, it's painful that it takes you that long before you can use the Circle R, because you cannot use that Circle R until you have a registered mark, but you can use a little superscript TM or SM if it's a service mark. So that's, did that cover the question?
Yeah, I think it was about cost. I think.
Oh, and cost. So it's going to cost you money. And I would say anywhere from your kind of do it by yourself online, where you spend between $500 and $600 because you're only paying the trademark people a couple hundred and you're paying a $350 filing fee for one class, to hiring an attorney, a good attorney, it's going to cost you $1,500 to $3,000 for all in comprehensive services. Now, the downside there can be an upside to doing it yourself. If you've completely made up the word, it doesn't exist in any language anywhere, and you're doing something that relates to nothing, and there's very little risk in your filing, maybe that's okay. But the problem you have with kind of doing this online, or kind of, I call it a budget, with doing a budget service, is you don't have any support and you don't have legal advice. And there's a lot of value in that legal advice. So the legal advice is going to cost more. The online route is going to be the DIY, or do it with a cheaper lawyer, is going to be maybe less expensive. But again, the whole cost calculus is not how much does it cost me right now. Cost calculus is what is the value of the thing that I'm doing, and should I invest in it? Do I want the $100 an hour lawyer to do one of the most important things about my business, or do I want the more experienced lawyer? And I don't want to,
Wonderful.
Yeah.
And in terms of experience, for those who are watching, what would you say when it comes to DBL's experience, why you would recommend us as the attorney for this process?
Yeah.
Your turn.
Well, yeah, I mean, Tom was talking about a lot of the background to this and the cost analysis, and we get that question all the time. It's like, hey, I found online that somebody will file a trademark for 50 cents, and why are you charging more? But we bring a lot of value into that analysis based on our years of experience. We've got, collectively
You're going to get your
decades of
trademark.
experience. Yeah.
I mean,
Yeah.
the difference is, yes, they'll file it for you, but if you actually want to get a trademark registration and have value, you need an attorney who knows what they're doing.
Yeah, we have attorneys that did the examining at the Patent and Trademark Office, so they know exactly what the examination process entails and what they're looking for in the applications. But there's really a lot of vetting that goes into the process that you need those decades of experience to bring to the table. Tom talked about the trademark search. Anytime you're going to apply, we'll run a comprehensive search first. Why does that matter? You think, oh, nobody could have thought of my brand. It's a totally unique brand. But there's more than 2 million registered trademarks in the United States Trademark Office. That's a lot of potential conflicts. And to be able to go through, not each one, but anyone that's close or similar, and to analyze, okay, well, how close is it? What can we do in this application to work around these potential problems? Same with goods and services. So there's a lot of value that, when I started doing this 15 years ago, I didn't have all the answers to those questions. But after doing it for many years and seeing so many things, you do get that experience.
And look, Tessa, we manage over 7,000 trademarks. We manage Fortune 100 companies' portfolios. We manage restaurant owners that have one trademark and, one restaurant. So the gamut. The federal government has us on contract, and we've been renewed every year for 7 years now with NIH, with Department of Homeland Security. We manage all their portfolios. I filed the trademark for the vaccine cards. It should have been filed a long time ago, but for the CDC logo. So the federal government trusts us to do that. We went through an extensive vetting process for that, and we're one of the top, sometimes 3, sometimes top 10, depending on what year it is, in terms of applications that are granted. So not in terms of applications that are merely filed, but granted applications. And that's really important statistic, because our having experience behind you means I'm not going to tell you to file a trademark that I think is going to fail. And I'm going to tell you that it's going to fail. You may say file it anyway, that's fine. But a lot of trademark companies or factories, they say, yep, sounds good. You're filing a trademark. We'll file it for you. That's what we're doing. We're filing a trademark, but it's not advice. And what you really need in the trademark space is advice.
Wonderful. Anyway, thanks so much, Tom and David, for that information. That's really helpful. I want to shift gears a little bit and talk about trademarks and creativity. What are some things for people who are watching and they're brainstorming the idea for their new business? What are some things to keep in mind when they start that brainstorming process?
Is that me? I think that's,
yeah, you can.
That's me. Okay. All right. So brainstorming process. So a couple of things you need to know about trademarks. It can't be something somebody already owns. So if you're brainstorming, like, it'd be a really good idea to be like Nike Computer Services. Nike is a famous brand, and you can't do that. So take out of your brainstorming any idea that you're going to try to trade off of another existing brand or be close to that brand, because you're going to fail. And the USPTO won't let you do it if there's a registration. And even if there isn't, you're going to get a cease and desist letter. So set that aside. The other thing you have to remember is there's a scale. So on one side of the scale, you've got something called descriptiveness. The less descriptive your mark is of what you're doing, the stronger it is legally out of the gate. However, from a marketing side, the less descriptive a trademark is of what you're doing, the harder it is for you to tell the consumer, you have to spend more effort to explain what you're doing. I'll give you an example. US News and World Report is on the bottom end of that scale because it's very descriptive. What do? They give you US News and World Report. They give you stuff. That's what they do. It's almost to the point of being generic, which you couldn't trademark, but it's not. They have a trademark on it. On the other end of the scale are trademarks like Xerox. That word literally means nothing in the English language. And the reason you know what it is and what that company does is because the owner of the brand created all of that association for the consumer. So that brand is much, much, much stronger out of the gate. It's much harder because they have to explain what a Xerox is. But US News and World Report didn't have to do much explaining. So you've got this push-pull. But the more fanciful and arbitrary a mark is, the stronger it is. And the less fanciful it is, the weaker it is out of the gate. Doesn't mean you can't build that brand value and own that brand, but the weaker it is legally out of the gate, the more likely it is to being more risk it potentially suffers. So those are things to think about when brainstorming names. The other thing to think about when brainstorming names is how much work do you want to put into this? Does the name mean anything in another language? So if you think you're being clever, and you're like, I'm going to start a pen company, and I don't have a pen for some reason, and I'm going to call it the Stylo Company, which stylo in French is a pen. The USPTO makes you file a translation statement. They're like, that means pen. That is completely generic. You can't trademark that. Yes, I get that it's in French, but it's the same word. So don't be too clever with that either. I think, David, any other thoughts on creative? We're not on the creative side. We're on the law side, but we do advise on the legal part of creativity.
Yeah, no, I think that pretty well covers it. You want to stay away from things that are really generic or descriptive. Find something in the sweet spot of, either completely arbitrary and made up like Xerox, or something that what we call suggestive, maybe that
Microsoft.
Microsoft is a software platform. So they're but they're not calling it software. They're calling it Microsoft. So having some way to differentiate your brand from the totally generic, but also something that you can create an association in the mind of consumers to then have a successful.
You just remind, or between complete. So on that scale that I was talking about, the very top are those completely fanciful words you've made up. And towards the bottom are US News and World Report. Above that are suggestive like Microsoft. In between those two, you have something called arbitrary marks. Amazon. Amazon.com is a good example. That's for online sales of consumer goods. Nothing to do with the Amazon rainforest. Apple Computers, another example. It's an English language word. We all know what it means. It's not fanciful, and it doesn't suggest computers, but it is an English language word. So an arbitrary brand is even stronger than a suggestive brand out of the gate. But don't use Amazon or Apple for anything because they're famous brands, and you won't get away with it.
Let's talk a little bit more about words to avoid, and I'll ask David this question. In terms of names and identities, what are things that people need to keep in mind?
Yeah, so you can't trademark somebody else's name. Anytime if I file a trademark application right now for David's T-shirt shop, they're going to ask me who David is and get me to sign a waiver or disclosure. So I can't, trademark, Coolio.
Joe Biden's
Joe Biden, yeah.
Donald Trump's T-shirt.
Exactly. So
that would be a problem.
We're going to
that's a little more obvious than David's.
But. Yeah, but it gets murky in terms of sometimes where you have a famous mark and it's actually your name. If my name was David McDonald and I wanted to open a hamburger shop, I would have trouble doing that because McDonald's is a famous mark.
Coming to America.
Yeah, coming to America. So we want to stay away from names of people that are not me, or names of famous people. You can also, and we talked earlier about descriptiveness. There's a descriptiveness factor for geography as well. So I'm sitting in Leesburg, Virginia right now. If I wanted to trademark Leesburg Law Firm, that would not be protectable because that's actually my geographic location. So stay away from geographic locations. And then there's some weird nuanced stuff in the Trademark Act that you can't trademark, the emblem of the U.S. Army, the presidential seal, flags of countries, various things like that cannot be either trademarked in themselves or incorporated into a trademark. So you'll have trouble if you have, the United States flag as the backdrop for your logo or something like that.
But you can trademark now, thanks to a recent landmark case, lewd words. Used to not be able to trademark lewd words, but there is a brand, FUCT was the brand, a clothing brand. And the USPTO said, that's lewd, we're not going to trademark that. And the US Supreme Court overturned that. So both the brand Fucht, I don't know how you want to pronounce that. And the band, there was I guess it was a K-pop band or something, I don't know, called the Slants. So both of them were able to get their trademarks, but the USPTO initially rejected them, but the Supreme Court had to come down and say that, yep, go ahead and call your plumbing service the shitty plumbing service. I don't know that that's a good idea, but you could ostensibly do that. Yeah.
Awesome. And before we get to the questions in the chat, I have one point I want to circle back on. We touched on this a little bit earlier, but can you give us some more details on the process of a risk assessment and why it's so important?
Sure. I think that one's me. So I did touch on it earlier. So a search is, a lot of people are like, why do I have to pay for a search? Why do I want to do a search? Let's just do the trademark. And the reason is, first, whenever we do a trademark search, you get a competitive landscape. You now know every other company that's using any mark similar to yours. Because remember, this is really important. We haven't said this once during the whole broadcast, podcast, whatever we're doing. So the standard for whether or not a mark is the same as another mark or close enough to another mark to be rejected by the PTO or to garner a cease and desist letter from the brand's owner comes from a case called In re DuPont. And that standard is there a reasonable likelihood of confusion as to the source or origin of goods or services in the relevant marketplace? And if you break that down, that standard is like, it's not like this. It's not patent. Does it read on every claim in a patent? Or copyright? Did I copy exactly that thing? It is like this. Could a consumer look at your mark and my mark and think, they probably come from the same place? That's really what the DuPont standard is. There are a lot of factors that go into it and things that bounce depending on where you are and what marketplace, is it sophisticated, all of that. But that's generally the standard. So it's hugely important to remember that a search reveals those likelihood of confusion factors. It lets you also craft goods and services for your mark so that maybe you can deal with some of the potential conflicts and avoid those. It lets you, so remember, even if I trademark Fuchs, if somebody wanted to trademark Fucked for clothing as well, they probably couldn't because they're phonetically the same, Fuct and the other word. Because, and that was probably a bad choice. I'm going to get in trouble for that. But the point is, even similarly phonetic words can't be trademarked. Or at least there's a reasonable likelihood of confusion with those two as well. A search lets you know that they exist. It'll pull up phonetic equivalents. It'll pull up even things that you're like completely unaware of in completely different classes that might be famous marks. It will also, our searches at least, give you an assessment of whether or not something might be considered descriptive. So if you're like, I'm going to sell plumbing supplies and I'm the toilet bowl company, I mean, probably you could do that, but the USPTO might think that that's descriptive because if you're actually selling toilet bowls, they're going to have a problem with that. And you would make an argument and we would plan around that and say, okay, well, let's make it clear that you're selling plumbing and other supplies related to, I don't know what the technical word is for plumbing, but the sewage arts, something like that. We'd come up with a goods and services description that would hopefully avoid saying we're the toilet bowl company, we sell toilet bowls, because you would lose. So a search gives you a lot of different things, including a commercial landscape.
Yeah. Wonderful. I want to go ahead and turn to some of the questions in the chat. I think this question is perfect for you, Tom, because I know how much you love Latin. So I'm going to quiz you a little bit here on your Latin. You mentioned words in other languages. How about a mark that is a play on a Latin root? For example, a cat company called, and they've got, I believe, the Latin word for cat. I'm not going to attempt to pronounce it, but maybe you know it. So what would you say to that question if you wanted to do a play on a Latin root?
So it's the exact same issue. It doesn't matter what language. There are some exceptions. So here's a weird case. We represent a lot of beer companies, and they come up with words and like, I'm going to use a word in Czechoslovakian. So the general rule is if it's a major language, and this includes Latin, because you may not be surprised, but a crap ton of people out of the millions of trademarks that exist want to file trademarks in Latin, and they require a translation statement, and they are considered the same word as the English word. So earlier I used the example of un stilo. And if you were to cat in French, the chat, or in Spanish, el gato, right? Those would just be considered cat in English. The same is true, and I don't know what it is in Latin. I assume it's close to one of those, like a Latin root of some kind. But it would be the same exact problem. Now, caveat to that, if you were to trademark a word from Rapa Nui, like that native language, there's so few speakers of that, you could actually use that word to describe the thing you are selling because there are so few people and it wouldn't be known by the general consumer marketplace what that meant. So there are And I think we ran into it with a name for Czechoslovakian beer, which described a style of beer. And the USPTO said, and we made an argument. They're like, not that many people speak Czech, but apparently the USPTO is like, enough people speak Czech. You can't call your beer after this Czech word for this style of beer. So it's pretty inclusive. But if it's a really obscure language, you can probably do it.
Or if it's like a really obscure term.
Yes.
If it's like a slogan that's only used in southwestern Michigan or something, or in a foreign language in some region, tiny region or something like that. So it really comes down to how likely is it that a consumer in the American marketplace that's bilingual would have that association. So things we can argue if we have.
I don't even know if Rapa Nui is a language.
I
mean, I know it's a place.
Well, we'll have to look that up after. We've got another question from Robin. She asked, can you touch on registration renewal requirements?
Sure.
6th year and thereon.
So it's actually between the 4th and 5th year.
5th and 6th.
5th and 6th year. So the 6-year requirement is a Section 8 and Section 15 affidavit. Section 15 is not mandatory. Section 8 is. Between the 5th and 6th year. So you have a whole year to do it. People still miss it. And there's even a 6-month grace period after the end of the 6th year, and people still miss it. But that is the Section 8 filing is an affidavit that you're still using it in commerce. Because remember, to own a trademark, you must continuously use that mark in commerce. Now, there are a lot of places or a lot of legal opinions that say you can stop using it for 3 years and go back to using it, but you have to file an affidavit between the 5th and 6th year that say you're using it in commerce. You have to file another one at the 10th year, and then every 10 years after that, you have to file that same affidavit. It becomes a Section 9 after the 10th year. The Section 15 affidavit, which some people are like, I don't want to file that, it's an extra filing fee. That is one of the most important things you can do between the 5th and 6th year. That is your affidavit of incontestability. You're basically saying, my trademark has been around for 5 years. Nobody's challenged my name on the registry. If I file this Section 15 and the USPTO accepts it, and I say I'm still using it, now you've suddenly wiped out a whole bunch of attacks people can make on your trademark going forward. So maintenance requirements. Between 5th and 6th year, always file your Section 8 and your Section 15, don't neglect. And then at the 10th year, you're going to file your Section 9, and then every 10 years after that. And if you have foreign marks, the WIPO registration requirements are even easier. It's every 10 years from the date of your WIPO registration. And you can manage World Intellectual Property Organization. Those are basically, that's the treaty through the Madrid Protocol that allows you to take your US registration, file in all these foreign countries, and you can actually manage those registrations directly through a central database called the WIPO data, the World Intellectual Property Organization database. That is a little too much, maybe.
It was very thorough. We've got a question from Gustavo. How different is the process to register a trademark brand that is currently live/dead? And then he has =dead ? So I think he's wanting you to clarify in terms of a dead trademark.
Oh, well, I mean, you can take this one.
Yeah, if it's dead on the registry, you can register. It's not going to block your application as a conflicting mark, but you'll still want to do some due diligence on that.
You still want to do a search
to
because
make
somebody
sure,
could be using it.
Yeah,
still,
make sure they've actually ceased use, because sometimes people will just let their registration lapse, but they're still doing business under that name. So it could still be a conflict in terms of their actual.
And not just a conflict. If they see that you've registered the mark or see you in commerce, they could go back, file to get their mark back. And since they've been using it in commerce, they can basically tack on that prior use that's in their prior application. So it is important to still do a search, even if you're trying to register what seems to be a dead mark.
Yeah. For something to be truly dead or abandoned, as we call it, there needs to be a cessation of use without an intent to resume use. Usually there's a presumption that at 3 years of non-use, then they're kind of done with it. It's been abandoned. So usually what I'll do is run archival searches. You can look at internet histories on their website, see if the website's live.
Wayback Machine is great.
Waybackmachine.org. Been down for more than 3 years, or if it just went down recently, because they can always bring it back to life if it's been more recent.
Wonderful. And then we've got a question from Juan. He's wanting some specific pricing information. Juan, if you put your email address into the chat, I'd love to put you in touch with our client services team after this so they could talk to you. So yeah, please feel free to send me your email and I'll make sure that they reach out to you directly. If anyone else has questions too, we would love to talk to you.
So is that, are we clear, Tessa? No more questions?
I think that may be it.
Okay.
If
All right.
anyone else has any additional questions too, please feel free to reach out to our client services team. Please give us a phone call. Is there anything else, Tom or David, that you wanted to talk about that you feel like you didn't get to touch on?
So the last thing we'll mention is that it's important that when you look for a trademark attorney, and whether it's us or anybody else, that that they're not just a trademark attorney, because you will have cease and desist letters. You will have trademark trial and appeals board cases. You will have related, you might have to license stuff. You'll have litigation. So if the firm doesn't do more than just trademarks, you're kind of selling yourself short, because your trademark only attorney, as soon as something happens with your mark, is going to have to reach out to you and say, okay, well, I've got a couple attorneys you can call, or I've got a couple friends, or hopefully they have a referral for you. So I think that's something just to consider. Trademark trial and appeals board cases are where you can test trademarks inside of the USPTO. We didn't talk a lot about that. It's a whole huge subject. And then of course, federal litigation, where most trademark litigation happens. Although oddly, unlike patents and copyrights, you can bring a trademark case in state court. There is concurrent jurisdiction, which is crazy. Almost nobody does it, but you actually can. That it's important that you have somebody that can do that as well, and at least handle that and give you advice on that with respect to your trademark. So yeah, that's all I have. Feel free to email us if you need a trademark lawyer. David and I are on dbllawyers.com, and love to hear from you.
Oh, we have one more question from Deanna Burke. Deanna would like to know, can trademarks be sold? Should they be put in your trust? That's a great question, Deanna.
Yes, trademarks are property. They're intellectual property. They're considered intangible property. They can be transferred. They can be sold. They can be assigned. The process for doing that involves twofold. One, you do the commercial side, like you'd sell anything else, a contract. And then you actually have to file an assignment with USPTO. But you have to remember that the owner of a trademark has to be the user of a mark. So you can't just be like, I've got a valuable trademark, I'm going to leave it to my kids. And if they stop selling the pizzas that you were selling, they actually lose their legal right in the trademark, because you have to be using the trademark. Now you could leave it to your kids and they could license it to another pizza maker. I don't know why I'm using pizza, I'm hungry. But that's, yes, all of those things are correct. And it can be put in your trust if you want, but I would advise you, and I'm not an estate planning attorney, but maybe to put some instructions in your estate plan, like, yeah, and by the way, you've got to keep doing my business to make this worth anything. So
it looks like the individual with the is in Latin wants to his
somewhere
I
between
don't either. That's why I keep avoiding
this.
saying it.
So.
Oh, I think Holly knows. Holly, you can turn on your mic if you want to.
It's gonna echo.
Oh, okay.
Actually, it may be easier if I spoke it rather than typed it, since I'm a horrible typer.
Sure.
I figured that I should talk about it anyway, because I'm also a horrible communicator. Let's say a cat is called Filus in Latin, and I want to trademark Ifili or Ifilishanato. So it uses part of the root, but it doesn't necessarily use the entire word in Latin.
Sure, that's probably going to be a fanciful mark. I mean, it's going to be judged on, if I took the word cat and changed it to catawampus. And I mean, frankly, as long as you're not selling cats under your cat mark, you can potentially trademark the word cat. I mean, you could trademark the word cat for sale of water bottles. I sell cat water bottle. I mean, I don't think it's a great idea, but I'm not a marketing person, but you could do that. So you're allowed to trademark common words. The question is, what are you selling? So if you're selling cats and you're taking a Latin root word, and if you're changing the Latin root word from what it means purely cat into a fanciful word, you can probably do that. I mean, you haven't done a search, so I don't know if anybody else is also selling cats under your fanciful word. But other than that, yeah, I mean, that should be okay. That makes sense? Maybe I over-explained. I don't know. Let me explain. No, it's too much. Let me sum up.
It looks like we've got somebody typing.
Okay.
We'll give them just a second.
We'll just smile and look pretty.
Yes, nod our
I don't know
heads.
if we can, so I did mention this. Remember, anybody who has a trademark and is using it in commerce, you should immediately today add the SM if you're doing services or the TM if you're doing goods and claim your common law rights in that mark, even if you haven't filed yet. You can do that. That's free. You cannot put the little circle R though, even though it looks good on the website and maybe GoDaddy's like free website maker puts it on there. Don't use it because it's technically illegal. It's technically a misdemeanor to claim a registered mark with the circle R. I will add trivia while you're waiting for the question. That little circle R is only a thing really in the United States and a little bit in Canada and Germany. No other country uses the circle R. Now, because US brands are so ubiquitous, it does make its way outside of the country, but it's not an official mark outside of the US. It's not an official indicator of registration. So other trivia. Most of the Middle Eastern countries are not signatories to Madrid Protocol, and you have to file national applications, as is true for most South American countries. And that's because they can't comply with the standards that WIPO set out to let them sign the treaty. But countries like Russia, China, Japan, Mexico, Canada, all of Europe, much of Africa, they're all Japan, I don't know, India, they're all signatories to the treaty. So we can all file.
Interesting. All right. So our next question is from Charles. He asked, can we add a descriptive word under a registered logo to explain to customers what we do? So can you add a descriptive word under the logo?
Yes, you can. So generally speaking, the descriptive element of a mark, if you file that trademark with the descriptive element, will be ignored, but they won't be ignored. You'll have to disclaim it. You'll have to file something called a disclaimer. So if I were to trademark, you know, cat water bottles, and that was my trademark, I would really own the brand Cat for water bottles. And I'm sorry if I'm stealing this from somebody who's going to do this, but I'd have to disclaim the word water bottles. So it could all be in my mark, and the mark would be considered Cat water bottles as a whole. But the words water bottles, I'm disclaiming the exclusive right to use that portion of the mark. You can also just trademark Cat for water bottles and put water bottles after the cat. So you'd see Cat, circle R, water bottles after it. And that would be fine too. You don't have to use the water bottles in your brand as part of the registration. But if you do file the whole thing, you would have Cat water bottles and the R after the whole word. So yeah, that's the answer. Pretty easy.
Okay, I think that wraps it up for us on the chat questions. So thank you so much, everybody, for joining us. And please contact us if you have any additional questions. Thanks, Tom and David.
Thanks.